Today we're going to continue our conversation about construction contracts.
Okay, I'm the subcontractor and I'm doing a great job. I'm hitting it out of the park. But the GC is in some skirmish with the owner that I have no control over. So then I don't get paid because someone upstream of me messed up.
The courts tend to stay away from restructuring contracts. They won't help you out if you've made a bad deal. And so they're going to let parties agree to whatever it is they are willing to agree to. And so if a subcontractor is willing to sign a subcontract that says, yeah, I've seen all that, I've read it, they may have unwittingly bind their company to do something that they didn't know they had bounded to do. Hi everyone, this is Chip Bachara with Bachara Construction Law Group, and with me today is the managing partner of our St. Petersburg office, Hugh Higgins. And today we're going to continue our conversation about construction contracts, why it's important to have them, and in particular, some of the clauses in the construction contracts that are important to note. Today, we're going to talk about flow-down clauses, what those are and how they can impact your contract. We'll talk about liquidated damages for delays, the good and the bad of those, pay if paid, which is a critical issue in construction contracts, defense and indemnity. There's a lot to cover. So Hugh, let's talk a little bit about flow-down clauses. Most contractors don't really appreciate what the purpose of them is, or even why a flow-down clause exists. Why don't we talk a little bit about that?
Right. Yeah. And in fact, I wouldn't be surprised if it's something that's kind of ignored in the contract, right? But yeah, a typical flow-down clause is going to be a clause, let's take the subcontract, for example, where the general contractor is forming an agreement with the subcontractor. And in that contract, it essentially says everything from the prime contract with the owner is hereby incorporated into this contract. And you, subcontractor, are going to be required to comply with all the requirements of the prime contract, as well as with this contract.
Right. And that's important for prime contractors to put, because they want to make sure that their subcontractor has all the same obligations that they have to the owner, to make sure the subcontractors have those same obligations in that subcontract, but by incorporating it, all of those provisions, as they call it, they flow down from the prime contract down into the subcontract. And that's why it's called a flow-down clause, and that's where it protects you. But it could also cause some problems. The courts tend to stay away from restructuring contracts. They won't help you out if you've made a bad deal. And so they're going to let parties agree to whatever it is they are willing to agree to. And so if a subcontractor is willing to sign a subcontract that says, yeah, I've seen all that, I've read it, they may have unwittingly bind their company to do something that they didn't know they had bounded to do. So you have to be careful on looking out for those flow-down clauses, asking as the subcontractor for those provisions, and as the prime contractor, figuring out how much of it you really want the subcontractor to see. And so a flow-down clause, while they're extremely common, you'll find them in almost every subcontract agreement. It's important to know the benefits of them. It's where the reason they're called a flow-down clause is because all of the terms and conditions of the prime contract between the owner and the contractor flow down into the subcontract. And like all things, there are pros and cons to them. You just need to be aware of what it is you're getting into. So let's talk a little bit about another type of provision that we see frequently in commercial construction contracts, and that's liquidated damages for delays. Hugh, talk a little bit about what those mean and why we have them.
Okay, so liquidated damages is essentially a simple way to get an amount of money for a specific issue. Typically, it's in the delay context. If a GC is late on delivering a project to the owner, rather than the owner going through and calculating how much interest they're paying to own the property, how much loss in revenue they've experienced as a result of the project not being completed, a lot of detailed accounting issues that could come into play and take a long time to litigate. Instead of dealing with all of those things that way, the owners typically want to have a liquidated damages provision that says, if you're late on this job, it's going to be $1,000 a day, $2,000 a day, $10,000 a day, depending on the job and depending on the financial circumstances. And those financial circumstances do have to have some relation to the liquidated damages provision so that it doesn't appear to be a penalty.
Well, you said something important there, Hugh, and that is that it cuts down on some of the litigation. If you don't have a liquidated damages for delayed clause or liquidated damages clause, then really the sky's the limit on what an owner may seek to recover from a contractor. What happens when the parties decide, well, listen, it's going to be this because we want to make sure you finish the job on time, because otherwise we want to penalize you. We're going to put in a penalty for you. Any problem with that?
The courts don't like it. There's very well-defined case law that says liquidated damages cannot be a penalty. So, if it is something that has no real commercial relationship to the types of damages that the party is going to experience, then it's a lot more likely that a court could strike it as a penalty and then not award the liquidated damages per day or per month figure. But then it's going to drop down to the calculation and proving up what the actual damages are. And now we're going back to the detailed accounting method and really proving up the facts for damages.
From my perspective, when I'm representing one of the trades, I said, look, we've got broad shoulders. We're willing to take the risk that we will perform our work properly, which is really what the contractor wants. And the contractor is willing to offer to the owner is that we can perform what we can control. We'll take a risk of that. But if we can't control that, then we shouldn't be taking that risk. And so we want to allocate the risk to the party that is most capable of managing that risk. And like you said, for liquidated damages for delay, if I'm the sub and I am truly impacting the critical path of that project schedule, then I should be responsible, but only to that level.
Right. And if I'm the GC, I want to know that I have some sort of carrot and stick in place, right? I have liquidated damages to hold over the subcontractor that's not showing up to the weekly meetings, that's not moving the work forward, and an easy way on a payment application basis, particularly at the end of the project, to withhold final payment and to keep retainage.
Yeah. One thing for both contractors and subcontractors to keep in mind is that's where the paperwork is so important. And make sure that on a daily basis, they're writing down which of the subs are there, what time their crew got there, how big is their crew. And the same thing for the subcontractor, where the subcontractor says, well, we're still waiting on the drywall guys to finish up this so that we can now go and paint. That'll save you a lot of time and expense in attorney's fees because there's less to argue about.
Right. So another big risk shifting aspect and important contract clause is pay if paid.
Pay if paid is sort of exactly what it sounds like, but it's a little bit of legalese, and that's a provision that you typically see in a subcontract where the prime contractor says, look, I don't have to pay you, subcontractor, if I'm not getting paid from the owner. Because if I'm the contractor and the owner's not paying me, then and I still have to pay you, that means I'm paying for a project that I don't have ownership on. And that doesn't do me any good. I won't last very long as a prime contractor. Right. Now, there's a flip side of that, though, for the sub, right?
Right. Because, okay, I'm the subcontractor and I'm doing a great job. I'm hitting it out of the park. But the GC is in some skirmish with the owner that I have no control over. I don't really know anything about it. And I can't get the owner to pay the GC because the owner's not paying the GC for anything. So then I don't get paid because someone upstream of me messed up.
Where the subcontractor can take on that responsibility is to put in a provision to the effect of, if there's any problem that the owner has with our work and they don't pay you for our work, then we're willing to not get paid for that. On the other hand, if the owner is withholding payment because of somebody else's work, then you shouldn't withhold money from us because of a problem with a different sub. And it's the broad shoulders concept that I like to use. Let's talk a little bit about defense and indemnity. That's somewhat of a vague concept, but why don't you explain a little bit about what that is?
Sure. So Well, defense and indemnity are two different concepts. They're related, but defense is going to be if I am the GC and I finish a project out and the owner isn't happy with the stucco or the windows or some scope of work, they're going to look to me first. And so I get sued, and then I have a defense and indemnity clause with my subcontractor so that if I have a lawsuit, I'm not paying for my own legal fees as a result of the problem with the subcontractor's work. So defense, that's paying for all the legal fees and expenses to defend yourself. Indemnity is what you actually have to pay in the form of a judgment or a settlement. And the two different obligations trigger at different points. Defense obligations are very easy to trigger. You just have to have a lawsuit that covers the particular scope that the defense clause is intended for. Indemnity, that's a matter of, does a settlement have to be paid? Or is there a judgment that has to be paid? And I like to ask it just in simple terms, in what circumstances or under what circumstances are you willing to write a blank check, right? Because defense and indemnity can essentially be a blank check.
The whole concept of this is the broad shoulders concept.
Yeah.
I'm willing to defend and indemnify you, Miss Owner, or you, Mr. Mr. Contractor, for anything that I do wrong. But unfortunately, we're seeing contracts that go beyond that, right?
Oh, of course. Sometimes the language actually says, if I, general contractor, am negligent, you, subcontractor, are going to defend and indemnify me for that too.
Regardless of whether the subcontractor was negligent at all.
Right. You just have agreed to give me this defense and indemnity as part of your risk share in this contract. Now, for those specific types of defense and indemnity provisions, where you as a subcontractor are agreeing to defend and indemnify someone else for that party's own negligence, there's a very specific way those have to be drafted to comply with the statute. A lot of times they're not drafted that way, but it's something you really want to look out for, because if you're signing up to write a blank check for someone else's negligence, that's a lot of risk.
So, Hugh, we've covered a lot of ground today. We've covered a lot of construction contract topics, many of which are very complex, and we've spent a lot of years fighting those, studying those, learning about those, and figuring out what works and what doesn't. Let us offer that service to you. If there's anything that we can do to help you negotiate your contract, figure out whether you've got a good contract or not, give us a call. We're happy to help. Thank you.